So the meat and potatoes, housing conditions law. So here's what we're seeing in our houses a lot. We're seeing all kinds of infestations pretty regularly. A red flag is that most rodents are nocturnal, so are cockroaches. You go into a home at 10 a.m., you see roaches everywhere, and you see mice. That's not a good sign because it's 10 a.m., they should be asleep. So that means the infestation is pretty bad. It's the dander from the rodents, but it's also the feces are an allergen for both the roaches and the rodents. So we see this a lot. And we do have kids who get bit by rats, different things like that. And also our families often can't afford to replace their furniture, right? So they're having bed bugs in their couches, or they're having mice chew up their mattresses. It's not cheap or easy to replace your furniture. We also see a lot of mold and moisture issues, and Kathy's going to talk about the mold law in DC, which is very specific about how this needs to be addressed. But if there's moisture in the same location for 3 days, you're likely to have mold. And this can lead to all sorts of things. Like I've had now 2 cases with mushrooms growing out of the walls. It's not great. It's a sign of recurrent moisture. So we see this not infrequently. This picture is pretty severe mold, but we get black spotty mold, brown mold. 2 things to know about mold. 1, the color doesn't tell you anything about like the severity or how it's impacting the family. And 2, you don't know that it's mold by looking at it. You just don't know. So that's something we would always need to get an expert for. We also see lots of poor repairs, things that are just not up to what's called a workmanlike standard, which is what's required by the law. We see a lot of plumbing issues, things that are, a larger systemic fix that needs to be done. You've got corroded pipes, and gosh, no landlord really wants to go and take care of all the pipes in a building. That's really expensive. So they're doing piecemeal fixes over the years, and then you've got this problem that kind of just balloons and balloons. So we get these sorts of things all the time. We hinted at reasonable accommodations, but this is something that actually comes up a fair amount. So reasonable accommodations are accommodations that somebody's entitled to based on a disability. The big ones that come up for us are asthma and breathing issues and the need to get a carpet out. So there's advisement on this, on what should be done from DOJ, but if there's, basically the rule is if there's something under the carpet, there's a finished floor, we can get that carpet pulled out pretty easily. And that is an accommodation for the family for the asthma. We also have issues. I know Kathy had an issue with a child who was in a wheelchair and was living on the 2nd floor, and there was no elevator, and the family was having to carry the kid up and down, right? So the family should have an accommodation to be relocated to a unit on the 1st floor so that that's no longer an issue. Reasonable accommodations can also include a change in policy. So this could be you have a no pets policy, but the family needs a support animal, or there just can be different things. So we want to think broadly. It's not just structural changes, but it could be a policy change.
And we typically won't float to you a case that is just a reasonable accommodations case, but sometimes reasonable accommodations issues might come up in the course of you meeting with the family. So just so you're aware of it.
Okay, so we've talked about the Housing Code. This is the Housing Code, DCMR Title 14. It's pretty explicit. It talks about, I'm trying to think of a good example, but there's pretty clear objective standards in there. The International Property Maintenance Code is also a good source. There's detailed sections for just plumbing or just electrical. Things to know if there's a conflict between the two. The International Property Maintenance Code trumps the Housing Code. But when people talk about the Housing Code, this is what they're referring to. If you remember back to property law in law school, there is also the common law doctrine of the warranty of habitability. So generally, even if we can't find the right place to stick it in from the Housing Code, there is this warranty of habitability. The landlord can't have a family living in a unsafe, hazardous, or unsanitary place, and they have to repair all the conditions. So this actually comes up a fair amount. The landlord must repair all the conditions. So let's say the family, I had this recently, a kid got locked into a bedroom, and I don't know if they're too young to unlock the door or something. Basically, the family had to break down the door to get back into the bedroom where the kids are, right? So the family broke the door, but the landlord has to repair all conditions in the housing. So the landlord actually has to make the steps to make that repair. Now, they may bill the family on the back end, but they actually need to do the repair on the front end. That is their responsibility, and we'll work out the financial issue later. But we get this a lot. Sometimes we'll counsel our clients, hey, if you did this, you may want to do it yourself because it may be cheaper. They may charge you $400 for this door, and you might be able to do it for $50. But ultimately, if we end up in court, the landlord needs to repair all the conditions in the home, however they were caused. The other thing that comes up sometimes is access, right? So like a tenant can't flood the basement and then not let the landlord in to fix the flooding issue. No judge wants to hear from a tenant who's like, I'm so mad about all these conditions, but also they can never come in. That really tanks our cases and makes a lot of people angry. And then landlords obviously need to have access generally for big safety issues. So they should have a key to the unit. They need to give notice when they're going to come in, but if there's, if something's on fire, they need to be able to access the unit to address that as well.
And then may not ignore any problem that constitutes. So it's like landlords have to do repairs, but this part is actually like about 24 hours. So they have to do repairs, and they're usually given about 30 days from DCRA to do generally repairs. These ones are usually given 24 hours to do anything that constitutes a serious threat. That's a fire hazard or a serious threat to life, safety, or health. And that can be anything from like they're sparking electrical to you don't have a fire alarm. So they're kind of a weird category there, but anything that falls in this life and safety, they really, really, really can't ignore. So that's what I think of those as you really, really, really can't ignore those, even though they probably let you ignore the other stuff. These ones you really have to do. Yeah. So just
we really mean it.
Those ones think about those probably are like the TRO worthy category of violations. All right, so I'm talking about the mold law because somehow I became a mold expert by accident. Wasn't what I set out in life to do, but there you go. You kind of fall into things. So mold. Mold is a weird category because everybody's like, it's just mold. But then when you look into mold, you realize that mold is really symptomatic of a lot of other things. Evan mentioned water, right? So water intrusion is a huge problem. As properties get older, the pipes get older, the roofs get older, and nobody replaces them because it's really, really expensive. 90% of properties in DC are older than 1978. So of our rental housing stock, at least, is older than 1978. So most of them need the major capital repairs, including probably the pipes being replaced and the roofs being redone. So that means that we have a lot of water intrusion, and mold is a symptom of water intrusion. And mold can actually have pretty serious health impacts of people who have respiratory issues, including all of our kiddos with asthma and all of our adults with asthma. As well as other people with respiratory issues. You'll find, if you look through the case law, Children's Law Center and Legal Counsel for the Elderly litigate a lot of these cases because also elderly people have a lot of respiratory issues that are impacted by mold. So in 2014, actually in 2013, we accidentally stumbled into this opportunity to create this really cool mold law in DC. We have actually the most comprehensive mold law in the country now. The Department of Energy and Environment actually oversees our mold law in DC. It's a compromise law. It's probably not what I would have written if given carte blanche to do what I wanted, but here was the compromise that the legal services community was able to get through. So together, the statute and regulations require a landlord, when given written notice that there is a suspicion of mold on the premises, to come and look for the mold. The word inspect is used, but they just have to basically come and look at it. Within 7 days. And then if they have to use if there's over a certain square footage of mold, which we'll talk about, they have to use licensed assessors and licensed remediators to actually fix the mold, which is a really big deal because before this law, what happened is when I'd be sitting over at the clinic, I'd see the painting vans come by and they would say that they did your interior painting and mold remediation, which meant they would come and paint over your mold. So the tenants would come and they would move into their beautiful new properties with the beautiful new paint. And within a couple of weeks, the walls would be black because the mold would just have come through the paint, because painting over mold does not solve your mold problem. But you can pass inspections by painting over mold because inspections are scheduled. So if you paint 2 days before your scheduled inspection, you pass your inspection. Because in DC, we only do visual inspections. Both DCHA and DCRA just do visual inspection. So we created a professional licensing scheme for mold assessors and remediators. You had to be licensed. You couldn't just hang up your shingle and say, hey, I remediate and inspect mold now. We imposed minimum guidelines for the remediation of mold, and we imposed penalties for landlords, and we created a private right of action for tenants to actually do something about mold. So mold was just defined as living or dead fungi. So I know Evan said you can't tell if something's mold, and like it might be dirt, but basically like if it's growing on something wet, it's mold. Now, I know if you're kind of older like me, you might remember like black mold scandals. So that isn't really a thing, actually. It doesn't matter what type of mold it is. The reason type of mold matters is for two reasons it might matter. One, it can tell you actually how long the water's been there. If you're an expert, it can tell you if it's a quick growing mold, like the water was a flood that happened and everything grew suddenly, or if it was a long water intrusion. That really doesn't matter for your case, to be totally honest. Probably. Or two, if the person has been tested for lots of allergies to different types of mold, it might help you. That actually doesn't really happen. Doctors don't typically test for lots of different types of mold allergies, or often any mold allergy, to be honest. Though in research, there's actually a really high correlation between kids with asthma and mold allergy. I think there was a 60% correlation between kids who had, I don't know if I'm using correlation right, but about 60% of kids who had asthma also had a mold allergy in one of the studies we looked at. So there was a very large number of kids who had that kind of allergy. So anyway, if it's wet and it's growing, it's mold according to the law, whether it's dead or alive. So indoor mold contamination, 10 square feet. So if you're like me, bad at visual things, 10 square feet, what was that? That sounded like a lot. So that actually came from the EPA guidance about one industrial ceiling tile. If you think of like those old fashioned ceilings in buildings, they wanted people in commercial properties, the EPA did, to be able to basically remove one of those old ceiling tiles and just replace it themselves. This building is too new, it doesn't have it. But if you think of like those old ceiling tiles with those ugly fluorescent lights, that's about 10 square feet. So it's not actually very big, right? It's not a huge area. It doesn't have to be one block of mold either. The law defines it in close proximity or from the same water source. So it could be spots of mold along the same wall. Often we find that like there's a dark black spot, but if you look closely, there's like light brown around it because it grew really concentrated where the water was, but there's a lot of light brown around it. Or from the same water source. So the roof leak caused like a bunch of mold all in this one room, right? So when it's there, it's really there. We usually don't have close calls where we're like, it's 9.5. We wish there was another half square foot. It's either like a foot or it's like 30 feet.
The foot is often like the caulking around a bathtub.
Right.
A lot of families will complain about that.
Right. So, right. Or it's like a tiny little leak under their kitchen sink that we're not going to get involved with. So visible, this definition is about to be changed. The DOEE has been updating their regs, which should be finalized because we submitted comments like 8 months ago. So the final one should be released. I actually have to get in touch to find out when they're finally releasing them. Right now, it's capable of being seen by the naked eye, either by a lay person or by an indoor mold professional. This is going to be updated to clarify, like, detectable by a mold professional, so they don't have to see it with their naked eye. Because we were running into problems where it was under a carpet, and the landlord wouldn't let us pull up the carpet. And we were like, but we know it's there because we can see, like, part of it, and they just won't let us pull up the rest of the carpet. Anyway, it was ridiculous, but is it visible using best industry practices? Anyway, so now following the written or electronic notice, they have 7 days to come and inspect. If the by inspect, they just have to come and look at it. If they see over 10 square feet, they have to get a licensed assessor in. So good landlords are doing this, actually. Now that they know about it, they are bringing in, I would say the licensed mold inspectors that they're using are of varying quality. So in terms of placing cases with you guys, if you are at a law firm, typically we are recommending people get their own assessor in. So we're not typically placing mold cases with solo practitioners or government people because we typically hire our own expert in mold cases because often the quality of inspectors that the landlords are getting are like, oh, there's no mold. And you're like, but I see it right there. And they're like, oh, I can't see that mold. That must be some dirt. So we do end up getting in a battle of the experts with mold cases. So we typically place those ones with people who can afford to hire the expert. That's really one of the only cases in these that we tend to hire experts in regularly. But anyway, that's sidetracking, but just to let you know. And And then the law says they have to remediate the mold within 30 days. So if there's under 10 square feet, there's guidelines issued by DOE how they're supposed to do it. So mold might be something incidental to your case. It might be like a rat case, and then you're like, oh, and there's also a little bathroom mold or kitchen mold that you're not going to have to professionally remediate, but here's the guidelines that I'm attaching to my demand letter. You need to do it safely. So you shouldn't bleach the mold. You shouldn't, there's all sorts of guidelines from DOE about how to safely remediate under 10 square feet, and we want you to follow those, even though you can just use your regular maintenance guy to do it. And the other thing behind this law, in addition to being dangerous to the tenant with possible respiratory issues, there is actually some research that prolonged exposure by the maintenance people to doing improper mold remediation actually can trigger respiratory issues that they might not have had otherwise for all these people that they were sending in to do it without the proper respiratory gear and containment. So we wanted to protect those people also with this law. For 10 square feet or above, they have these licensed people. The inspector remediator really should be different, and these new regs will clarify that it should be a different person. The tenant has the right to get their independent inspector, and with a court finding that there was over 10 square feet, you can get that reimbursed. Wouldn't count on it, to be honest. It's just not. It's not very likely with the way the court's working right now. You can get triple damages awarded if the owner acts in bad faith. So you provide your report, the owner's like, I'm sending my guy in, cutting out the wall and spreading the mold everywhere. Then you can, they act in bad faith, then you could sue for triple damages or connect them, and triple damages could happen. We focus on the mold law because some of our cases are really mostly mold cases that come in. We get a lot of mold cases, actually. It's a pretty common problem in DC, so I just wanted to highlight that. And it's a standalone law. It's not part of the housing condition. It's not part of the housing code. It says in there that a finding of a mold by a professional mold assessor is a presumptive housing code violation. So that's how we kind of shoehorn it in under the housing code, but it's not in housing code in and of itself. Questions? Yep. The question is there like a systematic way to hold the mold inspector responsible who aren't finding mold? So what I'll do when we do it is we send it over to the DOE person who's responsible for licensing and kind of like be like, look, here's ours, here's theirs. Can you revisit like whether they should be licensed? And they often will actually look at whether there's not that many licensed people in DC, and they will take a second look and like kind of review whether they should continue to be licensed. I think that problem's actually gotten less over. I feel like we've had less really bad reports and more just like landlords getting reports that agree that there's bad mold and then just not doing anything lately.
I would say the bad reports are like, we suspect water intrusion in the kitchen, and they came in and they sampled the bedroom and the living room, but not the kitchen.
Yeah, sometimes it'll be like the landlord direct them away from where the mold is, and they'll be like, the landlord didn't let me test the kitchen, even though I agree there's probably mold in the kitchen when you do cross of them, right? And so then it's not totally their fault. But originally it was those, and we did direct those to DOE, and I think those people are not inspecting so much anymore.
There's also a lot of like blaming the tenant, like there's all this clutter in the way, so we couldn't possibly do the inspection in the closet or whatever, and you're like, I see a picture, it's totally empty, I don't know what your problem is, right? Like, we get that.
The question was, do mold inspectors and remediators have to be licensed in the district or anywhere? The district is one of the only places that licenses them, but they do have to be licensed in the district, and DOE on their website maintains a list of who is licensed in the district. And it's licensed by person, not company. So the individual person that comes has to be licensed. And for remediation, there multiple people will work on the job. It has to be led by a licensed remediator, but not every person on the job has to be licensed. It has to be supervised by the licensed remediator. And typically our clients are so the assessor determines the scope of the remediation, and they'll often recommend that our client be put up in a hotel for a few days during the remediation because walls need to be taken down. So then we'll end up negotiating like where the hotel is, whether they need a stipend for food or transportation or whatever that's going to look like as part of the case. Questions? Okay, I'm going to move on to handling a case. So I just want to take a step back and talk about our client population for a second. I don't know how many of you have done pro bono work with our client population, but